So hello, I'm re-recording a program that we did recently, and I want to start out by giving due credit to the North Carolina Genealogical Society for sponsoring this program. We're so happy to work with them, and they were so helpful in getting attention to the program and getting our attendance up to 70 people at least. So we're very happy with that. The North Carolina Society that I was affiliated for many years as editor of their newsletter, then of their journal, and as a Piedmont director. It's just a wonderful group to belong to. I want you to encourage you to join societies still and look for the information that they can deliver to you, both in abstracts and book form, and in their programming, the information they can give. They're not irrelevant to your research and increasing your skills as a researcher. For this program, there is an attached um, handout that includes a lot of both abbreviations and terms that we use in legal research. So I want you to keep those in mind. You can get a copy of that by writing to me at the email address that is at the foot of this slide. Most of us think of ourselves as law-abiding, God-fearing folk. We know that our parents raised us right, and maybe the worst thing that we've ever done is a parking or traffic violation. And we just naturally assume that those attitudes have passed down to us across the generations, and that if anything, our ancestors were probably even more feet planted on firmly on the straight and narrow than ourselves. So it can be a bit of a shock when we discover that they were tangling with the legal system of their day, and especially when they were alleged to have done something that we find particularly morally objectionable. But one thing I've learned in genealogy is that you can never be prepared for everything that you're going to find in advance. There are always going to be surprises. The trick is to remain open to the information that you receive and to use these surprises as opportunities to burrow a little deeper, to know your ancestors better in their full humanity, not just according to your prejudgments of what they must have been like. So you can imagine how I must have felt back in the late 1990s when I finally managed to visit and interview an elderly cousin living down a dirt road in rural South Carolina. She was over 90 years old at the time. I'd never met her before in my life. I simply traced down from my great-great-grandfather all the people that I knew to still be alive, and I reached out to a number of them. I was bold enough to do that back then. She actually lived on the same land that our common ancestor, her grandfather, had owned. He was my second great-grandfather, though in a different house because his had been struck by lightning and burned in the 1920s. So she agreed to see me, but it took several trips for me to actually meet up with her because obviously she didn't know who this kid was, whether he was real. And I had to get her daughter, who lived across the field, on the phone and kind of explain my intentions and prove who I was before I actually got to meet with her. But eventually we did meet and we settled down in her kitchen, and she brought out her photographs and memories. You see, when she was a little girl, her grandfather actually lived with her own father and mother. He was the sort of man who tried to kind of hold fast to his children and control their lives a little bit. Some, like my great-grandmother, resisted. The story goes that she was actually wearing her wedding dress under her work clothes one day in the cotton field when my grandfather came by and picked her up in his buggy, and that's how she got away from her father. But others, like Maggie's parents, remained very close and well within his control. Now, my second great-grandfather Stubbs was a magistrate for most of his life, as well as a farmer. And he doted on those three granddaughters by that one son that he lived with, and one of them was Maggie. People in the neighborhood called him Captain Stubbs, and he used to go visiting neighbors and friends in his buggy and carried Maggie along with him. And she remembered these little trips and his favorite meal and the day that he died, what happened that day, all kinds of little things that she could share with me. He too liked to tell stories. Among those stories was the tale of how he barely escaped the Civil War alive, all the bloodshed he experienced, how he'd been elected the captain of a company. It turns out that wasn't true. He was discharged from the Confederate Army due to a physical ailment, his epilepsy. He was a buck private. He was never elected captain. I didn't know that at the time, but I give him a little credit. He was dealing with a little girl that really looked up to him and loved him, and she wanted to know why people were calling him captain, and he came up with this story. And maybe he was a little bit regretful that he couldn't serve in the military due to a physical ailment. But at the time, I didn't know, and I was eager to go to the state archives in Columbia and find out more about his service, which was one of the things on my agenda after this meeting. But she also seemed to know that he had once murdered a man, his brother-in-law, in fact. When Maggie saw my stupefied reaction to that little revelation, she quickly tried to minimize its seriousness. Oh, he didn't go to prison. It was justified, she said. And I tried to get more information from her about what had actually happened, but either she didn't know or she wouldn't tell me. So I left the farm that day with a mission. It would be my first real foray into court records. Now, you can bet that I hurried my plans for a trip to Columbia, to the state archives in South Carolina. I was looking for those Civil War service details, but also especially this murder that allegedly happened. And the records of the higher court, the criminal court in Cheraw District, where Marlborough County is situated, those records were located. I found the loose papers associated with the case, State of South Carolina versus T.P. Stubbs. I found the indictment, a formal charge of murder against my grandfather. I found a coroner's inquest into the body of Thomas M. Jones, who came by his death from a bullet in 1857. Finally, there were bits of recorded testimony, depositions, from individuals who were present or nearby at the time, from TP's sister, the victim's wife, from individuals like John Weldon Stubbs, his father, who had been a magistrate for many years himself, from his mother, Elizabeth K. Stubbs, from his uncle, Jackson Stubbs, and several others. I also found the term in the minutes of the court where the case was tried and discovered that the judgment of the jury was that TP had actually acted in self-defense of himself and his family. Thomas Jones was allegedly an alcoholic and a wife abuser. He had followed his wife to the Stubbs house, trying to bring her back home. He swaggered up the steps and he was brandishing 2 pistols and threatening the entire family if the wife didn't come out to him. So on the morning in question, Grandfather Stubbs was in the barn and he had a gun nearby, a rifle, and he knew what he had to do and he did it. He was just 20 years old. Now I wondered how it affected the rest of his life after that. The murder, the trial, the whispers, newspaper stories. Did he ever second guess his actions on that day? Did his sister appreciate what he had done, or did she end up resenting him for it? But later he was elected to the state assembly and he became a magistrate like his father. The community at least thought that he did right. I wasn't there that day. I was in no position to judge him or overrule the verdict of that time. But that experience of looking into that matter put me on a pathway. I gained an intense interest in criminal records, which I've carried with me to this present day. It led me to abstract and publish all of the loose criminal court papers for our neighboring county of Randolph in North Carolina when I was editor of their journal for 14 years. It was serialized across many issues of that journal. And those records have been a blessing to me over and over again, not only for my own research, but for any family that I found difficult to trace in Randolph County. It's not because I have any prurient interest in salacious and bloodthirsty details that I've taken up that line, although I have been accused of having salacious and prurient interest. In fact, most criminal matters involve relatively unimpressive events, relatively short-lived, inconsequential conflicts between individuals. But working methodically within Randolph County, records actually gave me a deeper appreciation for the kind of intricate details that these records contain, and how monitoring a family over time through them can reveal a good bit about the family dynamics and their relationships with one another and the community, the broader community in which they're situated. For my personal research, I have since investigated criminal records in many other counties in North Carolina primarily, Richmond, Robeson, Montgomery, Orange primarily, others. But recently, that I've been editor of the Guilford Genealogist in Guilford County, North Carolina, I was very disappointed that the criminal action papers don't survive from the 19th century before. Not even one shred, one document survives. So I began to look around for alternatives to those records in court dockets. And I came across what we know as the state dockets that cover all the criminal cases for the county from 1811 to 1868 in 6 volumes. Those are very, very useful records because most of the names involved in the cases are in there. And I've since published 4 volumes leading up to 1834, about 700 pages with indexes altogether. I have about 2 or 3 more volumes to go to get to 1868. So I'm really committed. So today, I want to introduce you to the myriad possibilities criminal records can open for your research. Our focus here is North Carolina alone, but every other state has analogous records. The names of the courts and the record groups may be a little bit different where you're working, but the essence of the process and the sources remains the same. You just need to consult a guide for whatever jurisdiction you're working in, probably from a state level archive, to get good guidance about how to proceed in a different place. Today we are going to define criminal actions and distinguish them from civil actions. Describe the court system as it existed in 19th century North Carolina. Describe the criminal process as it would unfold in a minor criminal case with all the different types of records that you would expect to find along the way, and we will give examples of each of those. We will discuss how you can find the records that you need for your research, explore some examples from my past experience, and then, although this isn't a live presentation and you can't ask me questions directly, you can always write to me at my email address, which I gave at the beginning, and there will be a repeat of it on the end slide of this presentation. Now, there's no way that I can cover everything in 1 hour or an hour and a half. So consider this just a beginning step on a journey which will involve many hours of research and learning through doing. Be sure to have a law dictionary, like older versions of Black's Law Dictionary, handy when you're researching to look up the odd legal term. Many of those will be in broken Latin. They weren't any more familiar with the Latin than we are. Another handy resource is Benjamin Swaim's The North Carolina Justice, which was kind of a handbook for justices of the peace that were used in North Carolina in the early 19th century. There are several others that were used, but Swaim's is the most prominent. Covers all the basic forms and legal requirements for the county administration and low-level judicial proceedings that justices of the peace were responsible for. And it's reassuring really to know that these justices were no more savvy about the law when they started than we are. They were just ordinary citizens doing their public duty. They were not legally trained. They had to learn as they went along, just as you will. And even those who had legal training tended not to be very sophisticated formal training, but informal training in law offices, viewing the procedures in courts, reading law, etc. Broadly speaking, legal cases are either criminal or civil in nature. There are some that are kind of an in-between, uncontested formality, as in the settlement of estates, called ex parte proceedings. But I think in general, we get a rough, intuitive grasp of the distinction between a criminal process and a civil process. But let's go through it anyway, because it's instructive. A criminal matter is basically an action in law in which the state has an interest in prosecuting an individual or a group of individuals or a corporate entity for violating a law. Penalties are punitive, involving loss of liberty, fines, and or bodily consequences, whipping, branding, humiliation, execution, ultimately, depending on what the laws prescribe at the time. The laws in question are generally those that maintain public order, protect private property, and the peace and safety of other citizens. Civil actions, on the other hand, are legal contests between private entities over trespasses, harms or wrongs, or violations of contracts, which the state is empowered in law to decide in favor of one, both, or neither parties, and assess damages if required. There are no bodily punishments in consequence of losing a civil case. You won't go to jail or be whipped, although there will be additional sums assessed potentially to compensate for emotional distress caused to the victim of the situation. The person bringing the civil case is usually a private entity and not the state. So in certain situations, however, this will not hold. As in many things in law, there are always exceptions. The state can bring a civil action against a private person or another entity. For example, when a public servant, like a sheriff or a county clerk, has taken out a bond to the state to execute his office faithfully, but fails in his duty, and the state moves to collect the penal sum of the bond as a penalty for his non-performance. But the easiest way to tell civil from criminal is usually by its title. However, if you've been paying attention, you'll know that doesn't apply in every case. But for civil cases, it's usually going to be private prosecutor versus private defendant, Jones versus Smith. And that B or VS in between for versus merely means against. The prosecutor is the party before the versus, and the defendant is the person after the versus. Now, if I wanted to reverse the order and put the defendant first, I would just use a different particle in between, an ADS period, ads, for ad versus in Latin, ad sectum rather in Latin, which means at the suit of. If Martha Jones is suing Thomas Smith, for example, then Smith would be at the suit of Jones. We could write it defendant first, or we can write it plaintiff first. For criminal cases, the state is the prosecutor. So when my grandfather was prosecuted for murder, it was state versus T.P. Stubbs, state of South Carolina in that case. If he had committed the murder in the colonial period, before our independence, the title would have been King versus T.P. Stubbs, or Rex, which is Latin for king versus T.P. Stubbs. So in Britain, the king represents the state figuratively, and crimes against public order are crimes against him. You'll note that the harm party, that is Thomas M. Jones, isn't even mentioned in the title. The state has taken up his wrong, because murder isn't generally considered conducive to public peace and order. And Thomas Jones is dead. He can't act for himself. So it's state versus Stubbs. Now, there are cases when the state is prosecuting a civil matter. And we've looked at one example of that, but there's another one that's very common that I want to bring up to you for your edification. Bastardy issues are legion, and that's merely a situation where the vestry, or later the county, requires an unmarried pregnant woman to reveal the paternity of her child, which she accuses a man, and he doesn't automatically submit to providing support for the early years of that child. A legal case may be enacted against him in which the state represents the woman in her effort to get support. The state has an interest, but it isn't a criminal case. It's a civil case. Strictly speaking, the title should read State for Martha Jones versus Thomas Smith, if Martha is accusing Thomas of being the father of her child. But It's usually just abbreviated to State versus Thomas Jones, maybe Bastardy in parentheses. It's usually interpreted and filed with criminal matters, even though it's civil, because of the title. Sometimes archivists and local officials administering these laws didn't understand the distinction of civil and criminal in any fine, precise way either. But that's good for us because we want to get those bastardy issues into the state dockets where they're easy to find and the information is very clear. So there you are also cases like assault, where both a civil and a criminal case can result from that. So let's say you get into a terrible fight with your neighbor over the hedge, dividing your property and whether it can be cut down or not, and who has the right to do that. So you just decide one day you've had it, and you go out there and you lay into it with your shears, and he comes out and you have a fight and you get hurt. Not only can he be prosecuted by the state for assault and be fined or jailed if the state thinks proper to bring charges, but you, as an individual, can also file a civil action against him to recover damages for your hospital stay and your pain and suffering in your recovery period. And then he might be able to countersue you if you had no right to civilly sue him for to lay into that hedge. He could civilly sue you for the damage you did to it. So it's very complicated. I don't want you to get too freaked out by this chart. It's very complicated looking, but it is really good because it illustrates how the courts developed over time in North Carolina from the beginning until the early 20th century. And it was prepared by Helen Leary for her book, North Carolina Research, which she edited, which is a book that I recommend to anybody who's doing North Carolina research. And the good news is that you can still get it from the North Carolina Genealogical Society. The main thing you need to remember from the chart is that in the 19th century, we basically have two dividing points, 1806 and 1868, in terms of what courts heard which matters. Before 1868, all lesser crimes, which we term misdemeanors, were cognizable before the Court of Pleas and Quarter Sessions, also called the county court, which met 4 times yearly, once every 3 months, hence quarter sessions. The judges for these courts were just the justices of the peace. They were all local men commissioned by the governor. They were not legal experts for the most part. They were also tasked with many workaday things regarding local administration of the county, like maintaining roads and bridges, regulating ferries, taverns, mills, handling poor laws, and taxation at the local level, just all kinds of things that they oversaw in addition to their judicial processes. All felonies were like murder, grand theft, horse stealing, which was a capital crime until the 18 teens, involving greater degrees of loss in terms of material or physical injury, and more severe penalties were the province of an entirely different court, the Superior Court. Before 1806, there were district superior courts in North Carolina, which covered several counties each. Guilford County, for example, where I am right now, was in Salisbury District, and that's where the court met, in the town of Salisbury. Randolph County, just south of here, however, was in Hillsborough District, and the court for that district met at Hillsborough, obviously. After 1806, each county had its own superior court. Now, there was less business for the higher court, so it sat just twice a year, usually in the spring and the fall. The justices for that court, however, came from the state level, and they rode circuit from one courthouse to another. They had to be professionals because of the gravity of these cases, so they did have some legal training, though it wasn't very involved at that time. Most people didn't go to law school. They studied with a lawyer. They read legal texts. They attended courts and got some practice through another lawyer, and then they were examined and admitted to the bar. Special terms of court could be called when there was a superfluity of cases on hand. Now keep in mind that both courts also heard civil cases, but at different levels of scale or seriousness. in the lower versus the higher court. After 1868 and the new state constitution, however, instituted after the Civil War, the Court of Pleas and Court of Sessions went away. It was dissolved, and all legal cases at the local level, civil or criminal, whether felony or misdemeanor, were heard by the same court at the local level above the magistrate's court, and that was the Superior Court. It was the survivor of those two courts after the war. But its functions were stripped of any local administrative duties that the Court of Pleas had held formerly in the antebellum period. That all went to the county commissioners, which we still have to this day. But keep in mind that there could also be appeals from one court to another. So if you, as a defendant, didn't like your verdict and you could post a bond, you could appeal from the county court of pleas to the Superior Court, and from there, post-verdict, to the state Supreme Court potentially. That is, if the Supreme Court granted the appeal, called a writ of certiorari, or cert for short. The importance of this is, if you're doing research in a county where the records have been destroyed for some reason or lost for a certain period of time, you would do well to check the index of the state Supreme Court for any cases that were appealed up the ladder and that would provide all the details that were lost at the local level. That's tremendously helpful. I don't think the index is available anywhere currently, but in the search room of the state archives. Likewise, if a defendant thought that he could not get a fair trial due to local prejudice against him or prejudgment, then he could ask for a change of venue, just as people do today. So that case that you're looking for your ancestor might actually be in an adjoining county, or maybe a couple counties away in their Superior Court docket or their local court docket. And don't forget to check neighboring counties when doing court research in general, because some of the business of your ancestors may have crossed county boundaries, could be interacting with people who lived in other counties. By the way, there's a lot of variability between counties as to what survives in terms of records and what doesn't. The good news is that everything that does survive from the early 20th century backwards in time in this category of records is gathered in a single place in North Carolina at the State Archives in Raleigh by county under a category called court records. Now, this is true not so much in some other places. If you look at Tennessee, for example, or Virginia, you very frequently have to go beyond the state library or the state archives to find court records that could still be in the locality, and they could have been lost there as well. So we're very fortunate that they've been put in one place here. At the North Carolina Archives, there are both original court records, books and papers, and there's some that are still in the county but have been microfilmed, and they are available there in the microfilm room if they haven't been actually accessioned, or they may be duplicates. So you can see what each county has in each category by either using the online guide to county records on the Archives website, which is a digital way to access it, or you can look at one of the published volumes of county records inventories that they've put out in the past. And any good genealogical library in North Carolina is going to have a copy of that county records guide. There's also another place you should look beyond court records category. You should probably look at a category called CRX records. Those are records of any type that at any point in their past have been out of official custody. And this is particularly important for court records because a lot of magistrates and justices sometimes kept some of the materials, maybe inadvertently, among their own personal papers and never returned them. And maybe a generation or two down the line, a descendant finds them and returns them and puts them at the archives. Well, because they were not in official custody all that time and their content might have been compromised in some way, they aren't put with the other court records. They're put in a category called CRX. Now, the dockets, basically there are two kinds of papers or sources available related to court proceedings in North Carolina. They're either going to be dockets or they're going to be papers. So let's talk about the distinction between the two of those. The dockets are bound records of a court's proceedings in abbreviated form. We're probably most familiar, all of us, with the minute docket. It's the most basic and important kind of docket. It records all the business in brief from each term of court where a case was heard, chronologically by term. And as you go through the minute docket, you will find the names of cases at the left-hand margin of each page described in the criminal situation as state versus defendant in a title, and beneath each title, what the court did with respect to that case at that term of court. So for instance, if the case came to trial, the jurors would be listed with the verdict beneath it, and if no verdict could be reached, it might be termed a mistrial there. Cases could also be dismissed by the judge or settled by the parties. Note particularly when jurors are withdrawn, that could have happened because they had a prejudicial entanglement with one of the parties to the case, like kinship or business relationship, or maybe a past quarrel with one of them. The sentence could also be listed. So reference to an appeal to a higher court could also be recorded there in the minutes, and the reason given for that appeal, which is going to be a legal reason. But very few important facts about the proceedings that occurred leading up to the verdict will be in the minutes. The minute dockets are just better for finding the duration and the outcome of the case. But there are a lot of other types of dockets as well, as you can see from this list. And these usually act as ways for the clerk to keep track of who is to appear in court, who is responsible for their appearance. That would be the recognizance or the appearance docket, whether they appeared, provide ways to find court cases across multiple terms of court, the trial or the reference dockets, trial being usually a civil kind of a docket, or record how and when judgments and court costs were to be recovered, the execution docket, for example. Each clerk of court might keep his dockets a little differently, so you sometimes have to sample the dockets that exist to be sure what to expect from them in any given jurisdiction. The best docket besides the minutes for our criminal interest are the state dockets, sometimes called criminal issues dockets after 1868. State dockets differ a little from one clerk to another, but in general, they contain the names of all the defendants, all the people bringing charges, all the witnesses summoned, people who secured bonds to appear or those who secured appeal bonds. As trials continue across terms, they will be repeated in a grid format from term to term until the trial is concluded. You'll also find the verdict and the final disposition sometimes of the case from the court's perspective, or whether the court had dismissed the case or the charges were dropped before a trial even took place. These dockets, therefore, will contain matters that are not in the minutes because those particular issues never got to the trial stage. And all the main people in the case are going to be noted usually, so that's great. The big exception would be the name of the deceased person in a murder case. You don't really get that name sometimes until you look at the papers, like the indictment or the inquisition over the body, the coroner's inquest, or maybe some of the testimony that was taken down at the time the body was found. But a dead person cannot be a party to a trial. That name may not appear in the docket or the minute book at all. So the dockets are the quickest way to find what you're looking for and what terms of court apply to your case, so that you can then turn them to whatever papers survive from that term for more detail. These volumes are easy to skim, as you can see, as from the example that's on the screen. There will be separate relevant state dockets, however, for the county court as opposed to the superior court, depending on what kind of criminal issue you're looking for. In this state docket example from Alamance County, we are looking at December term 1850, And all the matters here are criminal, obviously. Their titles are in the second column, their numbers are in the first column, and the titles all begin with the state versus somebody, an individual or a group of people. The third column tells us what kind of action is being heard. We see here indictments for affray, fornication and adultery, assault and battery, petty larceny, and usually they're abbreviating a lot of things too because they have a very limited space and they want to save themselves effort in writing full words down as well. And that's why I provided you with a list of abbreviations. You can get that list from me by writing to me at larry.cates@highpointnc.gov. We can also see whether an indictment has been brought, whether it's considered a true bill or not. That is where the indictment comes through when you pronounce a presentment or an accusation as a true bill. In the fourth column are the individuals prosecuting and the witness names. In the far right column is what the court did with the case this particular term. For instance, issuing capias writs, dismissing charges as to certain individuals and others, and not others, or determining whether to proceed with a case or not. A couple of instances there you see the abbreviation NOL.PROS. And that is for a case that has been dropped before it's been brought to fruition. So the other major category of record that we'll be dealing with besides the bound dockets will be the loose court papers, the dismissed court papers, or the dismissed judgment rolls. They collect all the loose documents that the court either issued or received in bringing any given case to trial. These include things like presentments, indictments, writs, summons for appearance, prosecution, appeal, written affidavits or depositions, witness tickets, and final bills of cost levied on the losing party. Do not, however, expect a complete trial record. That just didn't happen in the 19th century or before. There were no dictaphones. There was no recording technology. Select details of oral testimony might be recorded in a memorandum for a higher court if the case were being appealed. The important thing to be gleaned from papers, apart from written testimony, are the names. All the people associated with the case, from witnesses to securities to the accused and the injured person. Everything, however, is filed or recorded chronologically in North Carolina, not by the name or the number of the case, as it might be elsewhere. For example, in South Carolina, we have files or bundles that collect all the loose papers, and they're actually literally groups of papers folded, covered with a little cover and a bit of twine to keep it all together, or a ribbon, and you have to undo all that, unfold all that, refold it when you put it back together. That's a lot of wear and tear on the documents. But in North Carolina, they decided to just flatten everything, to just file it in boxes within folders by date. So there might be 4 folders for 1789 in one box, along with 2 folders from 1790. If your case started in 1788 and was concluded in 1788, you might find all the papers together, because generally they do try to keep one case's papers together within a year. But if it extends over 2 or 3 years or more, you might have to look in all the dated file folders for those years to find every bit of documentation that has survived. Now, let's work through the process of a typical criminal matter. First, how does the case come to the notice of the court? Well, it can actually be in one of a few ways. The most common is a complaint to be made before a magistrate or a justice of the peace. The injured party in the case, or their representative, let's say if they are a woman or a minor, will make a brief declaration of what happened and when and who is believed to be the culprit. This is what's called a bill of complaint. Sometimes on the bottom of that document will appear an initial list of witnesses, if any, to or surrounding the incident. These are often the accuser's witnesses alone, not the defendant's, because he's the one making this charge. The court refers to the complainant as the prosecutor, throughout the case, even though the state's attorney and the grand jury will have to make a determination whether to proceed with actually prosecuting it. And if you look at this example, this is from Orange County, North Carolina in 1782, where a John Robinson appeared before John Nichols, a justice of the peace for that county, and claimed that one James Kemp, who was a deserter from the Patriot Army and then already in jail, possibly for that reason, he was the very person who took his mare, a black mare, 15 hands high, he says, and a natural pacer, in November of 1780, nearly 2 years before. And at this time, horse thievery was a capital crime, so this is no light matter. Now, another possible way to bring forward a charge against an individual was through a grand jury. A grand jury is not the petty jury that we're mostly familiar with, or the trial jury, which actually renders verdicts. This is a different type of jury, and it has two purposes. One is to bring criminal and other matters forward that need to come to the attention of the justices. The jury consists of ordinary citizens, all male, all property holders, with community knowledge of events. If they know of a crime, they might report it. We call this a presentment. Witness names might also appear on this document, either on the back or the front. In this example from Orange County as well, in 1793, a grand jury presented three men, Thomas King, Cleburne Parish, and Robert Duke, with living in adultery with certain lewd women. It literally calls them lewd women. And they were thus guilty of fornication and adultery. I bet you didn't know that was a crime in the 18th century, in the 19th century, but it was. And think of the implications if you descended from one of these women who are likely to come up in the trial by name. So this would be a great source for you if you were concerned about the paternity of a certain ancestor. Likely the jurors who signed their names here, they had this information just from community knowledge, just from living where they did and knowing the people they knew and what was the common belief or knowledge of that area. Whether the state's attorney will actually prosecute this matter is another question. And the third and final way that a case could be brought to the knowledge of the court is through an officer like the sheriff or a constable. He could make that accusation of his own knowledge and submit it to the grand jury for review. I don't have an example specifically of that, but this is what would follow. This is a grand jury's second major function besides just providing presentments of things they know possibly have happened in their area. They decide whether there is sufficient evidence to proceed with a trial from any of that begins with any of these other methods. And if they find this, the bill of complaint or the presentment is then termed a true bill. If they make that determination, they will file an indictment. Indictments often have very formal language that should not be taken literally, seriously but not literally, as what actually happened. If they find that an accusation is not worthy of proceeding to trial, then they return a verdict of not a true bill, or the Latin ignoramus. Doesn't mean what it sounds like in this case. It means we don't know in Latin. So here in August of 1801, an indictment is filed based on a grand jury finding of a true bill against three guys, Joseph Morgan, James Morgan, and William Flintham in Orange County. And what do you want to bet that those two Morgans are related? And maybe Flintham is as well. They assembled at the house at night of John Abbott, broke in the door, and attacked his wife Susanna. However, you can't believe every detail you see in an indictment as a literal statement of fact. Indictments often follow very formal, stylized language. The event definitely took place in August of 1801, but it may not have happened on the 1st of August. I have seen many cases where the presentment or the complaint places a different date on a matter than the indictment does. It usually places the 1st of the month as that matter. It's just some kind of a convention. To what degree were they riotous and rutous on that evening? And rutous is an unusual word that you don't see except in these kinds of indictments. It just means a very disorderly, unorganized way. How riotous and ruthless were they? Did they beat, wound, and ill-treat her, as this document says? Did they put her in great peril and terror of her life? Um, they may or may not have carried arms. It refers to force and arms. That just means that it is a forcible entry, that she did not admit them of her own free will. They may not have been armed at all. You can't take it literally. Just pushing her aside and making her uncomfortable or angry would have been enough for this charge to have been brought. So, the three ways to bring a criminal matter in review are through an individual accuser, through a grand jury, or through an official accuser. And if the evidence is credible, the grand jury may then proceed to an indictment, like the one we just saw. The most typical charges brought against our ancestors in the county court, the lower court, court of pleas and court of sessions, were petty crimes like assault, affray. Affray is basically like a melee. It's kind of like a riot or a group of people just laying into one another, a brawl, where everybody is pretty much equally culpable. Theft of livestock, disturbing the peace, selling or buying from slaves. That was an issue because anything a slave had in his possession was considered to be his master's property, and he was stealing it if he was doing business with someone according to the laws of the time. Selling liquor without a license was a problem, called vending. Also, obstructing or failing to maintain a road or a bridge, counterfeiting or passing counterfeit bills or promissory notes, because at that time IOUs served as currency as well. There just wasn't that much currency in the economy. Perjury, disturbing the peace, keeping a disorderly house, does not mean that you weren't a good housekeeper. It means that there was a lot of wild and crazy stuff happening in your house. Maybe you were selling liquor, you were having people dancing, maybe you were keeping a bawdy house. Those are all other, there are other crimes like fornication and adultery that aren't prosecuted today, or unlawful cohabitation. I should note that attempted rapes or actual rapes are sometimes masked in these case titles and causes. Sometimes it's just shown as an assault. So if a man is assaulting a woman, you immediately should wonder what exactly was going on there. If a bed is mentioned, you know it was probably a sexual assault. If the words ravishment or assault with intent to ravish or to carnally know, as in the biblical sense of know, is mentioned, it's a rape. So those are things to consider. It was just as difficult then to bring rape charges, probably more so than it is today. Next, it's time to bring that potential culprit into court before a magistrate, or secure him to appear for trial in court, actually. We also have to bring in our witnesses, and we have to inquire with the defendant if he has some witnesses to add to the mix. The document to bring the defendant before a justice of the peace is called a capias writ. And capias is simply Latin for you're to seize or you're to take, as in taking or seizing the body of this person and bringing them in before the magistrate for what we kind of think of as an arraignment. It just requires that he be brought in before the magistrate. It does not mean that he's going to be incarcerated necessarily. In this case, Stephen Redding came to the Justice of the Peace, John Cabe, in Orange County again in May of 1801, and told him that Robert Allen was a person of no settled occupation, wandering about the county, and had left his family behind and was taking up with someone named Sarah Smith as a means to keep himself from the cold. And I guess you would consider this a charge of vagrancy. But that's the bill of complaint part. At the bottom is the capias writ part, as transcribed, that you should bring in Robert Allen to be examined and bound over to the court, if necessary. There are no witnesses listed here, but often there were witnesses on these pages that you might see at the bottom. Or they might be listed on the back of the document, as in the little endorsement that the clerk would create on the back side to describe what was within for easy reference. There's another case here where we see the endorsement against John Taylor, who was by profession a tailor, so he's John Taylor for petty larceny. On the back endorsement, we see not only the person bringing the charge, the person who was allegedly robbed, but that it was, whether it was a true bill or not, considered by the grand jury, and the list of witnesses is also there. There are no fewer than 8 witnesses with details of who served the writ or whether they were successful in serving it. So that's a lot of information. Now, it might take several attempts before a capias writ could be served. An alias capias is the second attempt to seize the body. A plurius capias is the third attempt. And you know, these people were trying to evade arrest sometimes, and they were not always easy to find. They might have to be issued to other counties because the county officials weren't aware of exactly where this person was living. On the reverse of each writ, the assigned constable would state whether he did or did not find the defendant, and sometimes provide notes of what happened. So if a capias or summons couldn't be served, you will often see "not found" written on the backside of it. By the sheriff or the constable or the deputy sheriff, or "not in my bailiwick" or jurisdiction, which means he's not here, he's not in this area, this is the wrong place to look for him. If the defendant had skipped town, you might also see "gone to Georgia" or something to that effect. Here we have an explanation for relatives' disappearance from local records, and maybe a location that we could track them in. The relatives said to the constable or other officer, "He went somewhere else. This is where we believe he went." So here's another example. There was a warrant to take the body of Colin McRae, who was a distant uncle of mine, unfortunately, in Montgomery County, North Carolina, for a very serious assault that was committed by himself and his nephews because they ran a store together, a little country store, a mercantile establishment. And this man that they came to his house at night, they believed that he was stealing from them, and they decided that they didn't have the evidence. They were going to take the case into their own hands. They took him out. They were disguised at the time, but he knew who they were. They beat him to a fairly well, and he was so injured that there was fear that he would lose his eyesight because of it. So this is a very serious matter. The court issued a capias to bring him in, to have him bonded to appear to answer the charges. And here, the executing officer gave a very detailed report of what happened, which is unusual. He said that he came in the dusk of the evening upon Colin McRae seated on the bank above the road near Murphy McRae's house, and he confronted him, told him he was going to have to come to court, wanted a bond executed to appear. Alexander Boggin was nearby. McRae asked him if he could indeed serve as his security on the bond to appear, and he said yes. And then Colin McRae decided to skedaddle. Basically, he took off. He was running so fast through the woods, the sheriff was after him, couldn't catch up with him. It turns out that Colin McRae does not appear in the next census record of 1850 for Montgomery County. He was not in that county. In fact, it seems he went to Mississippi and lived with a distant relative there, and is found in the 1850 census there. That gave me a clue of relationships with his family to other families named McRae, but also there are other clues about his contacts here, who he was familiar with. On the reverse of many capias writs are bonds made to appear in court on subsequent date for the case to begin. We call these recognizances or appearance bonds. We have to remember that in this period, jails, which were sometimes referred to as gaols, G-A-O-L-S, were small, expensive, poorly guarded, ill-equipped, and quite insecure. So ideally, only the most dangerous defendants, or those most likely to flee, are going to be committed to the jailer. Maybe the poorest, or the most friendless people who couldn't get anyone to sign their bond pending trial. Most people did make that bond and kept themselves out of jail. And they didn't have to put up any money. They were just acknowledging that if they didn't appear, they would pay the penal sum of the bond along with any securities who also signed that bond. That might mean the seizure of land or valuable personal property. Those bondsmen would also be liable. And if the defendant didn't appear on time on the given day, the bondsman would be asked to produce him. They could actually go out into the community, locate him, and bring him into court. And if they didn't, they were liable up to their half of the penal sum of the bond. So here is an example. In the case of Christopher Stubbins, he's been brought in to answer charges of assault upon Thomas Watts. At the foot of his bond is a section headed State versus Joseph Stubbins Sr. and John Collins Sr. That doesn't mean they're being prosecuted. They are the securities that he has gathered for his appearance in court. If he doesn't show and they cannot produce him, they are in trouble too. So the penal sum was 50 pounds, and that's enough to wreck many small farmers and laborers. Farmsteads have been sold for much less than that. And most people didn't have enough cash or personal property to cover something like this. And those two bondsmen were each responsible for 25 pounds himself if they couldn't produce him. Thomas Watts was also bound at the bottom, State versus Thomas Watts, as the person bringing the charges who would have to appear as a witness for key testimony that day. The implication is that bondsmen could be entangled with the defendant somehow, maybe his kin. There were far fewer bail bondsmen officially then than today. So if you know the bondsman in a case was not a court official or a lawyer or a prominent citizen of the county seat, like a merchant, you can assume that they are a friend or a neighbor or a relative of the accused, of course, or anybody who signs a bond for that matter. Of course, you're hoping for the latter. For example, if we go back to that Colin McRae situation with the return from the sheriff trying to apprehend him, Murphy McRae, whose house he was near that day, was his nephew, and Alexander Boggin, who agreed to sign on to his recognizance bond, was his nephew as well. And if I didn't have other records showing that, this would be very good evidence of relationship. Now, witnesses had to be summoned too, with or without security, but usually their bonds were so much smaller, like 10 pounds as opposed to 50 pounds or 25 pounds. And if something happened to keep a witness from attending court on a given day, they'd probably produce an excuse so they wouldn't have to pay that penal sum. And something to the effect of the dog ate my homework, basically. It could be something like the creek was high that day and I couldn't get across, or my wife fell ill and I had to look after her, or I was injured, or something of that nature. Maybe I got to court the wrong day. I thought I was supposed to come this day, but I actually was supposed to come a different day, and I wasn't there at the right time. I thought I had done my duty already. Note that any minors involved in the court cases at all would be represented by their parents or their guardians throughout the process, and women would be represented by their fathers, brothers, or their guardians, barring any of these. Accusations on behalf of women were often prosecuted by their menfolk. It was just the nature of the times that females were subsumed under the legal identities of their men. Now, most evidence, as we said earlier, would be produced orally in full hearing of the jury. No written record would be made of that, but occasionally, if the matter were particularly grave, like a murder, or if witnesses couldn't come to court because of their age or incapacity, illness, the fact that they might have been ill or distant from the court, maybe in another county or another state, they might be deposed and testimony written down and entered into evidence. And in the case, that's the real gold, because in the case of a traumatic incident like a murder or suspected murder, it was key to get the statements fresh and close to the date of the crime. That's the real gold mine, because if you are lucky enough to encounter it, it really enlightens you to a great extent about what was alleged to have happened and who was nearby and what was involved in that incident. We call these depositions or affidavits. A deposition being a court-ordered amount of testimony, or an affidavit being voluntary testimony made by the witness. The person who makes a deposition we call a deponent, and the person that makes an affidavit we call an affiant. All in your glossary within your handout. And then sometimes a court would put a series of questions from one attorney to the other party. We call interrogatories, and they would be allowed to write their answers down and as sworn testimony. In this extremely interesting case that you see on the slide, Stephen Madden Jr. and Solomon Barlow went out deer hunting in the fall of 1793 and ended up shooting someone's barrow hog instead of the deer that they were supposedly after. Now, a barrow hog is basically a castrated hog. That was done to fatten them faster. And in case you didn't know, at this time, you had to fence in your crops rather than your livestock. Most livestock was ranging free in the woods and mingling with other people's livestock. And that's why they had to be marked with a brand or clip in the ear that you might record at the court as a flesh mark so that your livestock could be officially distinguished from other people's. The question is, who was the malefactor? Who was leading whom into the situation? Madden's written testimony accuses Barlow of luring him. Samuel Thompson was known to be the owner of the hog because of the flesh marks that he had recorded. But note that Barlow took the carcass home to his father's house, and likely some of the family members will also be witnesses in the case that you might want to know who those relatives were. And furthermore, he gave a part of the carcass to his partner in crime, which kind of questions Barlow's story here. Madden's story, actually. So a case could be continued for some time as witnesses were marshaled and charges were contested or on points of law quashed or dropped. But if the case continued, the judge was eventually impaneled, the jury was eventually impaneled, and a verdict was given post-trial. There are no transcripts, as we said, of the proceedings. But in the early days, juries may not have even retired out of the courtroom to make their deliberations. They could have just huddled there, especially in petty matters. And one jury trial would follow quickly after another, sometimes with the same jury, sometimes with a minor alteration in the members of the jury. There just weren't that many jurymen called in so that you could have many different juries sitting on many different cases at the same time. But excluded members of the jury from a former case could have had some connection to either party, so make a note of them. If they were excluded because of partiality, there was a reason for that. The other side of that coin is, if you see anyone that you thought was related to your ancestor sitting in judgment in a jury on him, you know that he was not in fact related. And that's a key determination for you to make. That help you overturn some of your misunderstandings. If a jury couldn't reach a verdict unanimously, a mistrial would result. And the state's attorney would have to determine whether they wanted to go to the trouble and expense of starting a new trial for that defendant. If the defendant was convicted, he could appeal potentially, provided that he could provide another bond, an appeal bond, and give sufficient grounds to justify that appeal. Most appeals to the Superior Court would be granted, and that will be noted in the minutes. A brief record or memorandum of the case will be provided to the higher court, and these memoranda can be great sources about what might have occurred in the trial proceedings lower down, especially on the Supreme Court level, which was right above the Superior Court in terms of appeals. Don't also forget, if you have a sensational case like a rape or arson or something of that nature, to look for newspaper reports that may have existed from that time. They will greatly supplement what can be gleaned from the court's own records. And for North Carolina, newspapers.com is great because it includes digital version of almost every surviving newspaper from the 19th century or the 18th century in North Carolina. In criminal convictions, the penalties can range from hefty fine to lashes on the bare back, to time in the pillory in the front of the courthouse, to a few weeks of incarceration, depending on the laws in force at the time. One could also be sentenced to hard labor in the late 19th century on road gangs. Railroad crews, prisoners could be leased for labor to private entities or corporations for mining, manufacturing, turpentine production, or farm work. This leasing was far more common for black people or mixed-race people than for white people at that time, however. Long prison sentences were just not on the table until after the central prison was constructed in Raleigh in the 1870s, and it didn't really come into operation until the 1880s. In the antebellum period, penalties for enslaved people accused of murder, attempted murder, or insurrection could be much harsher than for whites, including hanging, burning, and display of physical remains in public places. Just imagine the difficulty of people in that category of getting a fair trial. They couldn't even be tried by their peers. Black people couldn't give evidence against white people, and so forth. In this example, we have an order to the sheriff of Orange County to carry out a sentence of corporal punishment, 30 lashes on at the public whipping post, to be delivered in 1782 upon a black man named Cy for harboring an escaped slave, a fellow named Cupid, who was identified as belonging to one Jesse Benton. 30 lashes was a lot, well laid on, as it's said here. Note that enslaved people generally could be tried outside of the normal process of a jury trial up until 1793. They were subject to summary justice in what we call magistrates and freeholders' courts, consisting of a mere 3 justices of the peace and 4 freeholding white men who were almost certainly going to be slaveholders themselves, 7 instead of 12. And such trials do not appear in any minutes, just in loose papers that may have been filed like this one. If you suspect that your ancestor was sentenced to state prison, those prison registers are more available now than they've ever been before. There are many sad tales there. And when I was doing research for the North Carolina Genealogical Society Journal, I got the idea of maybe reproducing one of those incarceration registers for the central prison, and I was told that I could only look at one name at a time. So things are a lot more open than they used to be. Beyond appeals, when a capital sentence or a long prison term was involved, you should try to determine whether a petition for clemency was filed for your ancestor with the North Carolina governor of that particular time. For instance, I mentioned that horse thieving was a capital offense at one point in the past, and the later part of that period where it was a capital offense, you get a lot of petitions to get people get that sentence of death remitted for them, because it was considered to be just not fair, just not proportional to the crime that was committed. So those appeals often provide reflections on the case from the lawyers, the witnesses in the case, maybe neighbors, even jurors, even judges were known to weigh in on what they thought of the proceedings and of the defendant. Petitions include the signatures of many neighbors who might attest to mitigating circumstances regarding the crime or the background or general character of the defendant, the number of his dependents, people dependent on him for a living, and their situation as well. And these will be found in the governor's letter books or the loose papers that are filed by year at the archives for each of our governors. There are some digitized gubernatorial records that are on the State Archives website, but they're generally not completely indexed, and they're pretty early. So it's still a matter of going there and looking for this material. In this example, which is not the original document, but an abstract that I made for the Genealogical Journal, the North Carolina Society Journal, an enslaved man named Bristow has been sentenced to death for the murder of Whitmill Robinson in Wake County, North Carolina. It was a particularly brutal sentence involving hanging and burning of his body. But these white citizens who petitioned the governor considered that Bristow would have been convicted of nothing more than manslaughter had he been a white man, and that his body should not be subject to such indignities which they thought were unworthy of the state. This petition was found in Governor Hawkins' papers and it's from the time of the War of 1812. By the way, notice that they are not petitioning for his sentence to be remitted, but simply the treatment of his body after his death, which is a little bit shocking. And finally, financial penalties and costs of the trial would have to be collected. Somebody's going to have to pay for all this stuff. Among these relevant papers, you will find the witness tickets, like the one at the bottom of the slide in the middle, in which each witness details how long he attended court and how far he traveled with all his costs, any accommodation charges. Because ready cash was scarce at that time, witnesses might ask the court to pay the amount due them to someone else to whom they owed money. The court might also prepare an overall bill of costs. It would delineate all the legal fees involved, the cost of all the filings and the writs generated by the court, the clerk's fees, the constable's and the sheriff's fees, the witness costs. So there's another chance for you to see all the witnesses, as in this example on the left in the State versus Arthur Sasser, by the way. On the back of an execution, the constable assigned to collect might detail what kind of property he seized to sell from a losing defendant, from a horse or a cow, maybe an enslaved person, right on up to an entire tract of land. And at other times, the state would end up having to pay the costs. So the main question in locating these records for the 19th century is not where they are. We've said that almost all relevant surviving records are going to be in the state archives among the county records, Supreme Court records, the state prison records, or the governor's papers. The question is, what is the most efficient manner of finding them if you have particular forebears in mind? Eventually, when Family Search has perfected its handwriting recognition technology, and Ancestry have done that, and burrows down to court records, which are, alas, always low on the priority list, it might be quite easy to just plug in a name and find all the records. Artificial intelligence is making that a future possibility, but AI is still struggling with personal names, and that's key to success here because the names are the most important bits. We can go in and read the records if we know that the names appear on certain pages, but it will be able to learn and improve with time with the input of knowledgeable humans. And so that's going to change for us. But already, at this present time, a lot of these records have never been imaged. The criminal action papers have not been imaged. You're not going to find them anywhere but at the state archives. The same for most of the state dockets, if not all of them. The minute dockets might be the only thing that are digitized and up on Family Search. So for now, the easiest way is to survey the state dockets of both the county and the Superior Court for the relevant periods of time, for any mention of any ancestors, and then to follow that up, if possible, by seeking the papers, followed chronologically, for those terms of court when the cases were heard. Unlike civil actions, very few criminal action papers have been imaged or microfilmed or digitized, and though minute dockets have been digitized for some courts, the other dockets, like the state docket, almost certainly has not been. So this research still requires you to travel and work patiently at the state archives, but it's well worth it, and I hope I've demonstrated that to you. So let's look at two pointed examples. I'm going to try to convince you even further of the benefits, genealogically speaking, that can accrue from study of criminal records. Now, anybody who has tried to research an entire surname across many branches of a family and many generations knows that there are always going to be better documented branches of the family and less well documented family groups. And that's usually because some nuclear families are headed with that surname or more financially secure than others. Some households are headed by women or involve illegitimate births, lose fathers early on, experience poverty, move through counties where documentation has been lost, or just move around a lot generally. So the branches that are less well documented in property-related records like wills, estates, and deeds are always going to be more likely to fall through the cracks. Sometimes court records can help fill in that gap. I've used criminal records, in fact, to document many poorer families through Randolph County records, free people of color, and enslaved people as well. So this timeline illustrates how one such family in Randolph County was put together with court records and comparisons across census years. ATDNA was also later enlisted to substantiate and verify what these records are suggesting. The problem of duplicate names with other Allred families complicates this matter. So studying the better documented families first helped. It's a kind of a process of elimination kind of a study, knowing that these folks don't fit into other better documented families. And that's the first step. But here is the essence of the matter. In 1788, Catherine Allred accused William Duskins of fathering her illegitimate child. And we know that that child was given his alleged father's surname, curiously, not the usual practice. And later he migrated to the Midwest. The bastardy bond was easy to find. The same year, Catherine Allred accused William Duskins of coming to her house in criminal records with a constable named William Richards and stealing a striped frock from her. She brought forward two witnesses, someone named Solomon Allred and another person named Elizabeth Allred. So what was going on here? We know that Catherine's illegitimate son's descendants do not carry the Y-DNA signature of the Duskins family. In fact, they carry the signature of an Ellis family. So maybe Catherine was dating William Duskins and he gave her a frock, but then she accused him of fathering her child, and it turns out falsely, and he turned around and tried to take it back, and he brought a constable with him. So these two, Solomon Allred and Elizabeth Allred, the witnesses that she called, must have been present when this happened. And it seems likely that since this happened at her house, they were living with her and living with a single woman named Catherine who was pregnant with a child. And it suggests to me that they were members of her immediate family. And that does not add up with any known Allred family that we already know from this period. So in 1794, a few years later, I think it's 1793 actually, no, 1794, Catherine had a second illegitimate son named John C. Allred. His father, according to Y-DNA of male line descendants, was from the Coode family, and that it might actually be his middle name. We don't know what his middle name actually was. They just used the letter C for his middle name. But then after that, around 1802, some 8 years later or so, Catherine married someone named Isaac Odell. She finally married. And with him, she had two children, a son named Isaac Odell Jr. and a daughter named Delilah Odell, born in the early 1800s. Later, in 1850, as a widow, she lived with that illegitimate son, the second one, John C. Allred. But if we go back to 1793, Isaac Odell, her eventual husband, is already in the picture. According to this record, the third one in the list, in 1793, the year before John C. Allred's birth, Isaac Odell, Catherine's future husband, was attacked by someone named Thomas Allred. It may be that Nehemiah was already fooling around with Catherine, and Thomas did not like it. It would appear that at this time, Isaac Odell was married already. His wife would die in 1800, and that would free him up to marry Catherine Allred. And Catherine may have been pregnant with John C. at the time, so you can see why the brother would be upset. When Thomas Allred was bound over to the court under a capias writ and answered Nehemiah Odell's claim of assault, Solomon Allred secured his appearance bond. If Thomas hadn't appeared, Solomon, as you know now, would have been enjoined to produce him in court or pay his part of the penalty that we were talking about on the bond. And that Solomon Allred is likely the same man who was a witness in the case involving the theft of the striped skirt about 5 years earlier. At least that's what it suggested to me. Now, putting these all together, We found a family that accommodates all of these people. We found a Thomas and a Solomon Allred, who were brothers and settled in Anderson County, Tennessee shortly before 1800. They married sisters there. From census and tombstone records, we know their ages. Tradition states that they were brothers. We found a household in the 1790 and 1800 censuses headed by none other than a Betty or Elizabeth Allred, which accommodates all of the chief characters in this drama, both age and gender-wise, including Catherine Allred, her two illegitimate sons, her apparent mother Elizabeth Allred, and her two brothers Thomas and Solomon Allred, who both went to Tennessee. And also we found a likely brother Isaac Allred and another unmarried sister named Diana Allred, who later lived with Isaac Allred, associated with this family. No one had ever discussed these particular Allreds as a group before. They had fallen through the cracks. We did not know who Elizabeth Allred's husband was, but he likely, given the birth dates of all of his children, died around the time of the end of the American Revolution. He might have been in service. He might have been a Tory. We don't know. We don't have any records of that. But he had no land, and this family had no property to speak of in North Carolina at all. I'm happy to report that autosomal DNA study of descendants does substantiate it, showing that these people are kin in one group. But without these two court actions, it would have been much harder to piece all of this together. Now, criminal activity, even on a small scale, can be a family affair, and this is an illustration in point. It can even extend across generations as the younger members learn the habits of the older, and poverty can make it a matter of survival in some cases. So one of the poorest ancestors I've ever come across was a Joseph Williams of Marlborough County, South Carolina, who died of exposure, according to a coroner's inquest in December of 1809. He was apparently drinking one night, walking home. He lay down in the woods. He just simply did not wake up again. And his miserable estate consisted of just a few tools and a horse and a few household furnishings, and that was it. But he was so deeply indebted that his chief creditor became his administrator and basically took what little he had. We do know his wife's name, Hannah, from that file. She would live with her children across a long widowhood and a rather miserable one. They had already been married less than 10 years, and all the children were quite poor too. In fact, they were so poor that she and some of them were labeled as paupers in the 1850 census of Marlborough County, South Carolina, meaning that they received public assistance, which was a great rarity and hard to get at that time. You had to be extremely desperate to get it. The wardens of the poor in Marlborough actually paid for Hannah's burial in 1855. That's the only reason that we know when she died precisely. So with a name like Williams, how would we ever determine where Joseph Williams originated? Interestingly, there are very few Williams heads of household in either Marlborough County or the adjacent county of Richmond County, North Carolina in 1800. We take that into consideration because this family lived in the far north of the county near the border with North Carolina, and some of these Williamses were very prominent and prosperous people, so we just can rule them out altogether. They are not going to be related to this very marginalized hand-to-mouth family of Williamses. Just before that year, though, in Richmond County, over the state line, in the criminal records of 1798 and 99, over on the right, I found an accusation against Simon Williams, Joseph Williams, and David Williams of stealing cattle, brought against them by a Mr. Robert Webb. Now, one of those records, there was listed as a witness none other than Joseph Williams, and his name was crossed off the indictment, so apparently he was considered not to be one of the miscreants. He was omitted from the final charge. And that could be my Joseph, or it might not be. But the truth is, in surveying all of the records of both counties through this time period, I've never come across a different Joseph Williams in that area, and I suspect it really is my Joseph. In 1800, in the census of Marlborough County, before he married Hannah, Joseph headed a household in Marlborough, and He was aged between 16 and 26, with an older woman over 45 who could be his mother. Now, these accused thieves, Simon and David Williams, did not remain in Marlborough County or even in Richmond County, but by searching their names with Joseph's, I came across another record in a different court. Just 3 or 4 years prior, in Pitt County, North Carolina, once again, a Simon and a David Williams were brought up on charges of cattle rustling before the New Bern District Superior Court. And as I told you before 1806, we did not have county superior courts. We had district courts that covered several counties. Pitt County fell within New Bern District. So we have a consistent crime. We have consistent names. And by looking at the remaining records of Pitt County, we know that Simon and David of that area did have a brother named Joseph. And I was able to compare the signatures on the documents. There's a recognizance bond for the Craven County, the New Bern Superior Court record on the left in the sort of the off-white color. And there's another signature for Simon in Richmond County, which is under my face, unfortunately, and they match. So after the theft accusations for cattle thieving, apparently Simon, David, and Joseph packed up their bags and they moved south and west to Richmond County, North Carolina, and they did the exact same thing there. Of course they would. I don't know for sure still if my Joseph is the same as this Joseph, but I very much suspect it was. And I found the name of their father. He was also named David Williams. So there you go. And these are just two of countless instances where criminal records have provided context for ancestors' lives. I told you of a situation in which a great-great-grandfather committed murder already. Well, I've also discovered a distant grandfather who was himself murdered in the 1820s in Orange County, and a first cousin in Orange who murdered his sister because he disapproved of her fiancé and he feared that a substantial part of his inheritance would be lost because she married. And he was hanged in Greensboro in the 1840s because he requested his trial be removed to a different jurisdiction. I found a situation in which a grandmother in Randolph County, North Carolina in 1842 swore out a warrant of the peace against her husband for abusing her so that he would have to maintain the peace or pay a hefty sum of money. And she was supported in that effort by one of her older sons. That helped me understand the traditional story in that family that another child, another son, had simply crossed the creek one night to join the war and never returned. The abusive husband, a country merchant, interestingly died the following year. I don't know whether that was related or not. In other cases, these records have illuminated community and family connections that I would not have otherwise divined. Like that time when a woman named Rachel Wallace testified in the 1790s in Richmond County about a hog's decapitated head found in her father, Barnabas Skipper's corn crib, and she overheard one of her brothers say that a couple other brothers and my ancestor Solomon Quick had put it there after stealing the hog from a neighbor and butchering it. And thus, the implication taken with other incidental records I have found suggests that Solomon Quick married one of the daughters of the Skipper family. A caution before we conclude. When using criminal records, please remember that accusations are not convictions. And furthermore, even if there is a conviction in a case, remember that innocent people sometimes end up losing the cases against them. After all, there were no Hercule Poirot, there were no Jane Marples in rural North Carolina in the 19th century. Furthermore, these are adversarial cases. Each side is going to present itself as the righteous party. The testimony is not going to be something you want to take at face value. And what happened on a given day between two individuals is not the complete story. Often these events were part of a larger history or a pattern of conflict that we just don't know about. Resentment, heightened emotions, Be careful when you render your own judgments. I hope that you won't be daunted by the trifling bit of court jargon and process required to decrypt these rich sources of information. I also hope you won't find the structure of the records too imposing. A little effort to learn, a little practice will put you in command of this research. In North Carolina, we're so fortunate to have all of our older collected court records assembled in just one place. And there's no better way to get to know your ancestors than to uncover them in these ledgers and folders. Though you cannot yet do this kind of research in your stocking feet at home, the effort required to access them is well worth it, and I hope that you will not neglect this opportunity. You can leave questions for me either in the comments section under this video, and I will answer them over time, and it will be beneficial to everybody else that comes along later too if I'm able to answer them. Or you can write to me at larry.cates@highpointnc.gov. And happy research.